So welcome everybody. I really do appreciate y'all being here. As Tina said, I am not an estate planning lawyer at all. I've been practicing law for about 28 years in Boca Raton, and I don't do estate planning at all. But as Tina said, I ended up becoming or getting a crash course in estate planning when my dad contracted ALS in February of 2022 and basically told my family, give me everything. I need to know what's going on with his estate from the get-go, and if it needed to be redone, we would redo it. And so due to that circumstance, I gained keen insight, as Tina said, in estate planning in general, but it certainly applies to ALS families. So just a little bit about me. We live in Boca Raton. My wife, Suzanne, is an accountant. I have two kids. My son, Aaron, is 23. He's in medical school at FIU. And my daughter, Lindsay, is 20, and she's a junior at Penn State University. Let's see if this is working. Okay. So as Tina said, my father, that's my father there, was the picture of health. He was a podiatrist, had just retired, and he contracted ALS, and he passed away, unfortunately, 6 months later. It was a terrible battle, but he never complained, not once. And I'm doing this, and everything I do, including raising money and speaking to you wonderful folks, is because of my dad. And a few months after that, I joined the Florida Leadership Council of the ALS Association and have basically dedicated the rest of at least my non-work life, to trying to find a cure and to helping families like you all in your struggles and in your challenges, and answering questions, doing everything that I can in my capacity, particularly as a lawyer, but also as a person, to help everybody navigate these challenging times. So why do we care about estate planning now? It probably goes without saying that talking about what happens after a person passes away is not an easy discussion. I certainly didn't want to have that discussion with my parents, but I thought it was important that we do it because we didn't know how much time my dad had left. There was a lot going on with my family. There was clinic appointments, there was respiratory appointments, there was physical therapy, there was home health care. All of that was going on. My mom, who was 75 at the time and not in great health, was quite overwhelmed. But at the end of the day, doing it now, having that discussion now, alleviated a lot of the chaos because it gave us, particularly me and my mom, a sense of relief that things were in order at the end and we wouldn't have to worry about it. And I think really that's the important point to make, is it's not fun to deal with this stuff now. You have a lot going on in your life, but getting something out of the way now will give you a sense of peace a little, and it'll make things much easier and simpler at the end for your family. The reason I can say this is because I lived it. We went through these discussions, I got everything in order with my family, and we were able to put that aside and focus on my father, his health, his happiness, and what he needed, and not have to worry about any of this annoying estate planning stuff for the rest of his life. And it ultimately worked out, and it not only was helpful for my father, but it was also helpful for my mother, because ultimately it's both of their estates that we're dealing with here. So what is estate planning? Estate planning essentially is multiple different types of vehicles in how to deal with your person and how to deal with your assets. Everybody's familiar with a lot of these, but these are essentially the 5 pillars of estate planning. You have wills, you have powers of attorney, you have advanced healthcare directives, you have trusts, and then you may have probate, which is a court process that goes through the estate. And That's important, and I'll explain why, because if you can help it and not have to deal with the probate piece, your whole family will be better off. Trust me.
So what is advanced healthcare directive?
I will explain that. Absolutely. It's a good question. So these are the things that all families, and quite frankly, this goes obviously for non-ALS families too. This goes for everybody. This is what you should do, but it becomes very pertinent and important for ALS families because you know what the future holds. So it's really important to do these things now. The first and the most important one is called a revocable trust. I'm going to spend the most time on that because that turns out to be the most important thing to give your family peace of mind. The second one is the Advanced Healthcare Directive. An Advanced Healthcare Directive is, as we call it in regular lay terms, a living will. That's an Advanced Healthcare Directive, and I'll discuss that a little bit. The third is called a durable power of attorney, and I'll explain what that is too. That's going to give somebody the ability to make financial decisions on your behalf. I'm not going to discuss the will. I assume most people either have a will or are aware of the will. If you don't have a will, it's important, but I'm not going to spend much time on it because I think everybody understands what a will is. So what is a revocable trust? Here's the important point. If you do not have a revocable trust, any assets in the decedent's name that do not have a beneficiary attached to them become assets of that person's estate. If the person who passes away has any assets in their name that have not automatically passed to a beneficiary upon that person's death, those assets have to go to probate court. And any creditors can go after those assets. There's obviously two important parts of that. Probate court is time consuming. Probate court costs money because you have to hire a lawyer. You don't have to. It's probably a good idea. But it ties up everything for several months, if not longer. So the idea of a revocable trust is to stay out of probate court. And therefore, any assets that you have, if you have debts, will also not be able to be touched by any of your creditors. For example, a credit card company. If a credit card is in your name and you have debt when you pass away, if you have assets in your name and that goes to probate court, that credit card company can come after those assets to pay back the debt. However, person passes away, doesn't go to probate court because they have no assets in their name, creditor gets nothing, and they have to write off that debt, and that's a good thing. I don't know why that went that way. Let's try this again.
So can we ask while you go, or we have to wait till the end?
Let's wait till the end just so I can get through this, but I appreciate that. So as I said, the goal here is not to have any assets in the patient's name, right? So for my father, he had assets. He owned a house with my mom. He had savings bonds. He owned a car outright. Those things were in his name. The idea with a revocable trust is to get those assets out of both my father's and my mother's name and put them in the trust. So who owns the assets? Who owns the house? Who owns the bonds? Who owns the car? Not my father when he passes away. Not my mother when she passes away, but the trust. And what can you use a trust for? If you own a home or a condo, you can change the ownership from you and your wife or just you to the trust. So right now, my mom's home in Buffalo, New York, is in the name of the trust. not in her name. It has no impact whatsoever on her life, whatsoever, except as the trustee, I get the property assessments. But that's it. There's no other difference. If you have artwork that you've purchased over the years, other valuable assets, you can put those, jewelry, you can put those in the name of the trust. All you need to do is tell the trust in the document, this artwork or this jewelry, and you name it in detail, is owned by the trust. For homes and condos, it's a little different. You actually have to change the deed, so it's in the name of the trust. It's not actually as difficult as it sounds. Financial accounts. Most financial accounts don't have beneficiaries attached to it. If you have an investment account with Morgan Stanley, right, and you've built up investments over the years, you have $100,000 in it or what have you, if you pass away, that money doesn't go directly to somebody else. That's in your name, right? There are not beneficiaries to investment accounts. But what you can do is you can tell your investment advisor, I don't want my investment accounts in my name anymore. I want it in the name of the trust. It doesn't impact your life at all. There's actually an easier way to do financial accounts than putting it in the name of the trust. You can do one of two things. You can actually put it in the name of the trust and say, so now the investment account is not investment account of Stuart Davidson, it's investment account of the Davidson Family Trust. It makes no difference to me whose name is on it. But when you pass away, it's not in your name. You can also do something called a transfer on death. You tell your financial advisor, I need my investment account to go immediately to somebody else upon my passing. And there is a form that they can have you fill out called a transfer on death. And that's what we've done with some of my accounts, where if I pass away, immediately my account goes to my wife. And if she passes away, immediately it goes to our children. You can do that. It functions the same way as a trust. The only difference, as I said, is that there's a trustee that controls the trust instead of person. So I control my parents' trust. But I talk to my mom all the time. I ask her, is there anything you need from me? I say, when I get a property tax bill, I send it to my mom. I say, you pay it, because you're the one who's still living in this house. So she actually has no impact on her life, the fact that her home is now in the name of the Davidson Family Trust instead of her name. And that's so she has no assets at the time that my father and then my mother pass away. That is, by far and away, the most important thing to do prior to somebody's passing, is to get a revocable trust in place. Lawyers will do it. It is not expensive. It is a form you fill out, and you have to have notarized, maybe a couple witnesses that the lawyer will have, and you're done. This is important. I will repeat once again the reason. The reason is you do not want to have any assets in your name when you pass away, so those assets are protected from creditors, and you don't have to waste time in probate court. If you take away anything from what I say this morning, take away that. Let's try this, wrong button. So that's it. I'll spend a couple minutes on the next two things. One is the Advanced Healthcare Directive, the Living Will. Another document that you should have, the same lawyer that you go to prepare a revocable trust can prepare a living will or an Advanced Healthcare Directive. These are legal instructions regarding a patient's medical care if he or she is unable to make those decisions. Why do you want a living will? Because if you are unable to make a decision, at least your doctors and your caregivers will know exactly what you want. So if you're terminally ill, if you're in a coma, late stages of dementia, near the end of life, having a living will directs your doctors and your spouses and your children of exactly what you want to happen with your life. You appoint the person that you trust. Obviously, if you haven't spoken with your mom in 40 years, you might not want to name your mom as the person in charge of your living will, but you should appoint somebody that you trust that's going to follow your wishes. I don't know why this isn't working. Do you guys have the ability to? Oh, that one worked. All right. And obviously, it's important that if you are at the end stages of your life, you don't really want to put the burden on your family to make decisions that are really gut-wrenching. So if you tell them in advance through this living will what you want, that decision's been made for them, they should honor it, and it makes that a little bit easier.
Is this kind of a do not resuscitate
It is.
agreement?
It is. It is. That is part of the do not resuscitate is generally part of the living will. This is acting a little, there we go. And obviously sometimes, and you all, if you're from Florida, you remember Terry Schiavo. That was a situation where there was a dispute between the husband and the parents about what Terry wanted to do at the end of her life. This removes that obstacle. Durable power of attorney is similar to a living will, except it has nothing to do with health care. It concerns financial and business decisions. So you can appoint somebody to make financial and business decisions and legal decisions if you are incapacitated. You appoint someone just like you appoint in the living will, and they can interact with the banks, they can interact with lawyers, they are your agent. And your durable power of attorney, just like your living will provide specifics as to what you want to happen and what your power of attorney is able to do. And it's very important and helpful, especially with banks, when you might need to move money around or what have you. The types of transactions that a power of attorney can engage in are buying and selling property. So if they want to sell a house, manage bank accounts and investments that I just said, paying bills, that could be important too, especially if somebody's incapacitated, filing tax returns they can do. These are all important things. If you do not have somebody who can do that, then you have to go to court, have the judge find that person incompetent to handle their own affairs, and then appoint somebody to act. That's time consuming, and all of you know ALS, time is not on our side often, and getting this done in advance makes things a lot easier. I think that is it. There's my contact information if you want to write it down, or you can email or call anybody at the ALS Association who will give it to you. As I said, I am not an estate planning lawyer. I just know a lot about it because I went through it and it worked like a charm. But you are always, every single one of you, free to reach out to me at any point in time, 24/7, via email, phone. I will always respond. I will always respond. But with that being said, does anybody have any questions? A bunch of people. I'm going to start on that side and move. So all the way in the back. Let's let microphone.
Okay, I own a home in Florida.
Yes.
And I recently did I think it's called a quick claim deed,
Yes.
or Lady Bird. So
Yep.
is that considered transfer of death?
No. So who did the deed go to?
Both my sons
Okay. So that means that it's in the name of your son at this
as
point,
well.
right?
Right,
As
I'm
well?
still on it.
You're still on it. Okay, but presumably when you pass away, your sons will be the sole owners.
Okay, so it's good. I
It
don't have,
should be fine. It should be absolutely fine, as long as they are the sole owners and you no longer have any interest in the home at the time of your passing.
but I mean, I own the home and I can still sell it now.
Without your son's approval?
Yes.
Okay, that might be a little more tricky then, whether it's in just your name. So property does not generally act similar to a transfer on death.
Okay, so I need a revocable trust?
I would do that out of an abundance of caution, absolutely.
Okay, and one quick question. So I'm thinking about going to Indiana, but
Yeah.
I want to keep the property here.
Yep, that's not a problem.
It'll
You-
still, I can still protect it?
Absolutely, absolutely. You can do a revocable trust from anywhere in the country. Yes, you had a question.
How about joint accounts? Like,
So joint accounts, right, so joint accounts, it's a great question. Joint accounts don't have the same problem because there is a right of survivorship. So once somebody passes away, it becomes solely theirs, right? The rub is, then that person has to deal with it in their name, right? And then they have to go through the whole situation of who's gonna get that asset when that person passes away. That's why it was like that with my parents. Instead of saying, well, from my dad, now it's just in my mom's name, well, then we got to deal with the fact that it's in my mom's name. So instead of dealing with that, we put that account from a joint account to the name of the revocable trust, the Davidson Family Trust, and then it's in neither of their names, right? So you might as well do it now, if you got to do it at all, for both people. Yes.
So, I would just say, we have Echo Family Trust.
Yep.
Everything's covered, who gets what, when. Anything else that I need to do with that?
No, I mean, it just makes sure that the assets are in the name of that trust. That's the important.
Everything is Echo Family Trust.
Perfect.
My investment,
Yep.
my house.
You can even do insurance policies and everything. Yep, absolutely. You should be good, yes.
Just to mention, as a retired realtor, when you put your property, your home or condominium in a revocable trust.
Yes,
Your homestead exemption no longer exists. It's like a new purchase, even though there was no money, and the property taxes change.
that,
I've seen, in South Florida especially, a property they paid $20,000 for 30 years ago is $1 million. All of a sudden, that tax goes to $20,000, $25,000 a year, and they say, oh, hell.
all I can tell you is neither of those happened with my mother. Now granted, the homestead wasn't an issue with my mother because they have a home in Buffalo, New York, and so their home in Florida was a secondary home.
Right. That's why I didn't.
Right, yes.
So if we name, first of all, we were told, we were going back and forth on this issue with trust, we were told you don't need it. Because if we name beneficiaries, not only do we name them in all the bank accounts and financial other folders, so we name the beneficiaries, the names are there. So we were told there is no need for a trust. The names are already indicated in the,
So there's two issues with that. The most important one are estate taxes. If everything is done through the will, if your will says that our home passes to beneficiary X, then estate taxes come into play,
okay.
okay? And the revocable trust, and you'd be very careful as to what asset you have that have beneficiaries attached, because the home doesn't have a beneficiary.
Well, we named in the will beneficiaries.
Right. That
Uh,
is, if a trust is not created in the will, then you're going to have to deal with estate taxes.
And through the trust, you do not
No.
need, what's the difference on the estate taxes?
It's usually based on amount that the estate tax will actually come into play, but I have been advised that a will is not having money go from one person to another through a will is not advisable.
We did a trust and it was only $5,000 for everything.
Right, that's about,
It's not a big deal.
it's not. That's very similar to how much we paid.
Yeah, okay, that's fine.
One more question.
Yeah, I do have a question too. So if the home is joint ownership.
Yep.
And there is a will that after the person dies, the home goes to the spouse, let's say, then you wouldn't need a trust. I think if you do a trust, then you lose all the benefits that you have, like homestead exemption, maybe tax, if you're
Right, that's what
disabled, you lose, you know, your benefits there, so that's a iffy thing to do. I think if you do have a trust too, don't you have to also do a specific tax return? You have to do a tax return for that trust?
Yes, you do.
Also, so
Correct.
there's a lot of stuff involved.
It's not
So-
complicated, but as I was saying to the young lady in the back, having it owned jointly just kind of passes the issue on to the surviving spouse, for now, but
If the partners passes and then the home is in my name as well, it wouldn't go to probate at this point because I am in the will.
right, and
right?
that's the point I was trying to make is,
Yep.
but then when you pass away, the problem arises, right? Because my mom's still alive, but I don't know what her lifespan is. And I would talk to an estate planning lawyer about that, absolutely. I think we have one more question.
Yeah, I think it kind of went back with her because military, we also have disability benefits, and if the home is not in the veteran's name and it's in a trust, I think we lose the tax.
Right.
So
And
that-
I would not, for the life of me,
I
try
think
to
that's a
counsel you
question.
on military
All right,
benefits at
I
all.
was I was
but-
wondering if that was your situation too.
All right, thank you all very much. I appreciate your time.